We provide a platform, a cloud-based platform, which automates the agreement process specifically for financial agreements. We are most widely used, it's probably fair to say, in the retail and motor finance space today in the UK. And in the motor finance space, we are probably the most widely used service of our kind amongst providers like Motonovo, Close Brothers, but also the captives and many of the brokers. For those of you familiar with the business case, you can take a mental break for 30 seconds. For those of you who are not, what's interesting about the business case for automating your agreements is A, it's extremely robust, but B, many members here have not yet automated the agreement process. So if you think about the state of play today for the agreement process, and I'm not talking about origination here, I'm talking about from the point at which you believe a customer is good for credit, right through to the point at which that customer drives away in a car. It's a kind of mixture of automated and manual processes today, many of which rely upon third parties who the finance company does not necessarily control, which often gives them heartburn. So from manual processes from things like printing out agreements to filling in agreements, checking documentation, to scanning, storing, faxing. You're all familiar with this kind of process. If that end-to-end process is completely automated, the business case is significant. Some of the business case is obvious, and some of it may be a little bit less obvious. So the obvious side of the business case is if you automate properly, you can increase sales. If a customer can walk into a dealership with a non-premeditated credit purchase, he didn't know he was going to make a credit purchase, he hasn't brought with him all his agreements, but if he can walk into that dealership, and if he can drive out 30 minutes later, having presented nothing than what was in his wallet and in his mind, then the likelihood is that in that single sitting, you're going to sign up more customers. You're going to lose less customers. If it's easier for the dealer, that helps conversion. If the dealer gets paid faster, it also drives behavior. So conversion tends to increase if you fully automate the process. The second point is lower costs. All of those manual processes cost money. If they're done wrongly, it costs money. If you get fines from the regulator, it all costs money. So if you can automate those things such that the process is either done correctly or not at all, you tend to drive down costs. But the third area is, and honestly, it was an area that we didn't expect for the business case to be so robust, was compliance. The issues that our clients have prior automation are predominantly around their beholden or their dependencies, particularly to dealers, for the compliance process. If you think about it, you have financial institutions who have critical dependencies on third parties who they don't completely control. Now, if you're able to automate the end-to-end process such that the dealer no longer has to bother with a compliance regime, that responsibility is taken away from him, and the lender then controls the compliance regime, and if that process is executed properly, suddenly you can increase the extent to which you can retain and maintain and also demonstrate compliance. And the other point is around carbon. I think that's an obvious point. The more automation, the greener a process is. So the business case is robust, but then the question is, why haven't more people adopted electronic signature? Electronic signature has been around for almost 20 years. And to answer that question, if you take a kind of cursory glance at some of the big financial institutions who have dabbled in electronic signature, the more you look, the more you find folks who have had issues, shall we say, in the deployment of automation. And the issues ranged from a series of things, from fears about compliance, all the way up to losing in court with electronic evidence. Now, all of these folks on the screen you're probably familiar with. They're not stupid. They all took legal advice. And to a man, they all produced systems which were legal in theory, but were found wanting in practice when the time came to test them. So the short point here from this slide is producing an electronic signature process which is legal does not necessarily guarantee enforceability. So if that's accepted as a tenet, then the next question is, who do we seek, or who do we go to advise us on what achieves enforceability and not just legality? Because for my clients, Practical enforceability is the place to be. Theoretical legality is almost meaningless to them. So what you're about to see is 6 principles by which our clients ensure enforceability and not just legality. And these are not our principles. These are principles defined by some of the world's leading electronic signature experts. In fact, in your pack, you have a 3-pager from a woman called Lorna Brazel, who is a senior partner at Osborne Clarke and the UK's leading specialist on electronic signature. And in that document, she details the steps which financial services companies should think about taking to ensure practical enforceability and not just theoretical legality. But this slide is really an attempt to summarize her views and the views of some of the judges and professors who presided over the cases on the previous slide. Some of these points may seem obvious, and some are perhaps a little bit more obtuse. So the first point is identity audit trail. In the electronic signature world, you lack, obviously, a physical signature. So you need some means by which, retrospectively, to categorically establish the link between your customer and his contract. So there are 2 things to bear in mind when you're identifying a customer. The first point is that throughout the process, you have to validate the identity of the customer. You have to be sure that you're dealing with a valid customer. But the second point is that you have to be sure that it's the actual customer that's signing the agreement. And you have to be able to prove both of those things retrospectively, possibly years later. And so validation can entail all sorts of things, but beyond AML. So identity checks, name, address, date of birth, bank checks, documentary checks, all of which really need to be automated. There's no point in having an electronic signature process if you're photocopying driving licenses and uploading them. So thought has to be given to how you automate all of those validation processes, but also how then do you prove that it's the customer signing the agreement? If you just have a tick in a box on an agreement, how do you know it wasn't the dealer? Or how do you know if the customer's applying from home, it wasn't a relative? So what kind of, for example, knowledge-based authentication checks can you build into the signing process to put the smoking gun in the customer's hand, to prove retrospectively it was the customer that signed and not the dealer? So the next point, and this may seem obvious, you need to be able to prove exactly what the customer was looking at when he signed your agreement. Many of the more traditional electronic signature services, which are excellent for many purposes, but not necessarily fit for purpose for motor finance, don't categorically guarantee to be able to reproduce what the customer was looking at when they signed. And there are various reasons for that, which if you want to approach me afterwards, I can discuss with you. But just like in the paper world, it's important to be able to reproduce everything the customer was seeing when they looked at the browser, when they signed the agreement side by side with the dealer. The third point, and I thought the first speaker raised some interesting points here about use of video and also what the claims industry is going to do when PPI runs out. Most claims against lenders are not the customer simply saying something like, this wasn't me. They're claims around intent. I didn't understand this. This wasn't clear. This due process wasn't followed. So the extent to which you can mandate a process, record a process, and even replay a process directly correlates to the protection you can afford yourself, both from the customer's lawyer, and from the regulator. So think about use of video in recording customer processes. The fourth point is true copy. Again, seems obvious. Very often, more traditional processes produce a copy for the customer, which is really just a facsimile of the terms and conditions to which he subscribed, which is not a carbon copy of what he was viewing when he was signing the agreement. So any differences between what the lender keeps and what the customer keeps can be exploited. So really you should be thinking about the customer keeping an electronic carbon copy of what he saw when he signed. The fifth point is around persuasive evidence, and this is more a practical point. If you have a system which produces lots of technical evidence, which is held in lots of different databases, if you are beholden to your IT team to go and find, retrieve, possibly even explain that evidence, it puts you in a difficult position. Lenders should have evidence which is compelling, which is easy to find, which is easy to use, and which crucially does not rely upon IT. It's not IT's business to defend your legal position. And lastly, if that weren't enough, and by the end of this slide you will probably know more about electronic signature than many lawyers, sorry if there are any in the room, we need non-repudiability. We need the ability to establish the evidence as admissible. And if that sounds obtuse, let me break that down to a couple of points. The first point is unity. If you think about the entire process, an automated electronic agreement process, you're producing lots of different kinds of evidence, from the identity, from the anti-impersonation, from the document, from the process that the customer went through, the process that the dealer went through. And all of this evidence you have to be able to prove is linked, which is actually more difficult than you might expect. Just having a serial number referencing those different bits of evidence doesn't prove they're linked. It just proves they have the same serial number. So you have to prove that they're linked and ideally packaged together. And very lastly, you have to prove that all of that evidence has not changed whilst you owned it by accident or design, i.e. that it has to have integrity. So a single package, all of the evidence has integrity. If you can do all of those 6 things, and if you can deliver that in a seamless customer process, then you have enforceability as opposed to just pure legality, which is why very often IOCs will end up replacing a more traditional electronic signature provider. Thank you.